Hello everyone. Very good evening to all of you. Welcome to the Officer Adda 24/7, the special session of your BRBL subject in the English medium language. So those candidates who are new in this session, please see the session so that you can easily, identify that which types of questions come in your exam. Okay. So today we are going to do a mini marathon of module C. Okay. So right now we have just done the module D, and C and D modules are very important from the examination point of view, okay? Because D module contain total 9 acts, C contain total 10 acts, so 19 act out of 25. So that's why C and D module is very much important. Now let's start with the session module C. Number one question on the screen is that the integrated ombudsman scheme 2021, we know that in this ombudsman scheme there is a merger of three ombudsman which provide a cost-free redress of the customer complaint involving the deficiency in services rendered by entities that is regulated by RBI. And what are the regulated entities? That is a bank, non-banking financial institution, and your this one payment system. If not resolved to the satisfaction of the customer and not replied within dash by regulated entity. So whether it is 31 days, 28 days, 25 days or 30 days, which is the right answer? And this session is live class. Everyone have to give me the reply. Yes, ma'am and sir. Come on, give me a reply. In this session, I have just put some case studies question, some one-liner question, etc. Okay? The way the question will be asked in your exam, the same pattern I have followed in the today's session. Now tell me class, suppose if the regulated entity that is merged into the integrated ombudsman scheme have not given reply within dash days now, so the customer can file complaint to the ombudsman. So what is the right answer? Come on guys, that is very simple question. Hello Anirudh sir, it's a D. Sir, excellent. 30 days is the right answer. Within 30 days, the regulated entity have to give the reply. And what are the regulated entity? That is a bank, that is NBFC, and the payment entity. So these are the regulated entity. They have to give the reply because the customer is not satisfied with the services which is given by them. Okay, that's great, sir. Excellent, guys. Next question. For the purpose of integrated ombudsman scheme, the RBI has divided how many jurisdiction? Jurisdiction means the area in which we can file the case. So whether it is 4, 10, 15 or none of the above. Tell me. We know that in the initial days, the banking ombudsman scheme 2006 in which we have to go to the banking ombudsman right now, but now everything is merged into the one ombudsman. So what will be the jurisdiction of this one? It's a 4. Anirudh sir, it's a 4. Could you tell me the 4 jurisdiction? Where are the 4 jurisdiction? Hanji sir, could you tell me the 4th jurisdiction? What are they? So, sir, right now, in the previous days when the banking ombudsman was there, 22 jurisdiction was there. But right now, none of the above is there. Right answer. Only they have a one jurisdiction, that is a Chandigarh. Chandigarh is the central place in which we can file the case. That's it. So the answer will be 1. So that's why none of these is the right answer for this question. Is that okay? And please just give the answer in which you are sure that yes, this is the right answer. Okay, now let's move the next one. Who would be the appellant authority under the integrated ombudsman scheme? Who is the appellant authority? Governor, deputy governor, executive director or CGM? Tell me. Who is the appellant authority, sir? Come on, guys. Everyone have to give me the reply. Everyone, please come. Governor, Executive Director, Deputy Governor, or CGM? That is very simple question. That is very simple question. Tell me. In the banking ombudsman, the appellant authority was deputy governor, but in the integrated ombudsman scheme, in this, executive director will be the appellant authority. So C is the right answer. Is that okay? So you have to learn C will be the right answer for this question. Next. What is the maximum amount of compensation that is a monetary relief for the loss of complainant's time, expenses incurred, and for harassment, mental anguish suffered by the complainant that RBI ombudsman can award, whether it is 1 lakh, 2 lakh, 1.5 lakh, or 2.5 lakh. That is important. You know now, in this time, sir and ma'am, the without options question will become. So this may be the without option question, this type of question. Because in this question you have to write just the numerical number. So whether you have to write 1, 2, 1.5, 2.5, etc. Tell me. What will be the right answer here? See, in the ombudsman, the maximum limit is up to 20 lakh. That is a maximum limit. But if we talk about the harassment and the mental anguish, okay, so for this one, the punishment will be, the award will be 1 lakh compensation. So up to 20 lakh is the highest compensation, and for the mental anguish, you have to remember 1 lakh will be the right answer. So this is the right answer. Okay, guys, this is the right answer. Next. With reference to the Lok Adalat, as we know that the Lok Adalat is there in the Legal Service Authority Act, which of the following statement is correct? Lok Adalat have jurisdiction to settle the matter at the pre-litigation stage. What is pre-litigation? The case which is not started or initiated in any court. So before initiation in a court, that is called pre-litigation stage. So the Lok Adalat have jurisdiction to settle the matter at pre-litigation stage and not those matter that is pending before any court. Second, every Lok Adalat consists of either serving and retired judge only and not any other person. C, none of the statement is correct. D, Lok Adalat can deal the matter which are of civil nature, not the criminal nature. A very good question. A very good question, guys. Why you people are not replying? Why? Please reply the answer. The session is live, class. Session is live. Nikita ma'am is live. Tell me, which of the following is the right answer? With the reference to the Lok Adalat, which is the following is correct? D. Lok Adalat will deal with a matter of civil, not criminal nature. Anirudh sir, you are absolutely wrong. See, the first thing. Lok Adalat have the jurisdiction to settle the matter at the pre-litigative stage. This is absolutely right. And not those matter pending before any court. This is wrong statement because Lok Adalat can handle the matter which is pending in any court. So this not is the wrong word which is mentioned in this one. So that's why this cannot be the right answer. Now, every Lok Adalat consists the retired and serving judge. Yes. And not any other person. No. Not is not the right answer because any other person will also appoint in the Lok Adalat. D. Lok Adalat can deal civil, not criminal. No. The criminal nature, which is of less heinous crime, that can be handled by the Lok Adalat. So that's why this is also the wrong statement. So none of the statement is the correct. C will be the right answer. C will be the class right answer for this question. Excellent, Meera ma'am. Most welcome. Okay, that's great, ma'am. Next, which of the following matter are not refer to the arbitration. The arbitration word we have read in module C, that is MSME Act. Okay, so see, when the court is there, the court is basically to solve the matter. So in India, there are right now various types of ADR, that is an alternative method in which the matter can be solved. So this is Lok Adalat, Ombudsman, Tribunal, arbitration, conciliation, mediation, etc. So you have to tell me what cannot be referred to the law arbitration. Civil matter, matrimonial. Matrimonial means the husband-wife matter, banking matter, property matter. Which of the following is the right one? Meera ma'am, please see the question. Not referred to arbitration. And ma'am, in arbitration, Meera ma'am, basically, the matter in which the agreement is there, that matter can easily solved by the arbitration. So ma'am, in this question, civil matter can also solve, banking matter can also, property matter can also, but the matrimonial, the husband-wife matter will not solve by the arbitration. Excellent, Anirudh sir. So B is the right answer. Good, Meera ma'am. Okay, B is the right answer. Now let's do the next question. In dash, the bank guarantee payment of installment spread over the period of time. It means X person have to give installment to the Y person, right? And for that installment, the bank have given the guarantee. That is a bank guarantee. So there are three types of bank guarantee. That is the deferred payment guarantee, performance guarantee, financial guarantee. That is written in the book also. So you have to tell me guys that in this question, when the bank have taken guarantee in the installment, which kind of guarantee is there? Deferred, performance, financial, or statutory guarantee? Everybody have to participate in the question answer session. Only Meera ma'am and Anirudh sir is giving me the answer. Please guys, tell me the answer. The session is live. Nikita ma'am is live. Yes. In financial guarantee, the bank, suppose Nikita ma'am have to pay 1 crore to the tax department. For that 1 crore, bank has given guarantee. That is called financial guarantee. Performance guarantee, Nikita ma'am have to perform a project. For that performance, the bank have given the guarantee. And deferred payment, excellent Suman ma'am. And in deferred payment, this is the right answer. So A will be the right answer, because in the installment basis, if the bank is giving guarantee on the installment that the bank will pay, that is called deferred payment guarantee. Excellent ma'am. Good. Okay, that's cool ma'am. According to 107, no need to learn the section of TP Act, a lease of immovable property from year to year or for a term exceeding dash or reserving a rent can be made only by a registered document. It means what should be the year? 1 year, 2 years, 6 months, 3 year. That only it can be done by the registered document. Tell me. And what is lease? Lease means in which we are giving the possession of immovable property to the next party. That is called lease. This question is from TP Act. In the TP Act, we have a mortgage, we have a lease, sale, actionable claim. That is the main topic of TP Act. Yes, tell me, guys. This is very simple. This is very simple, class. If the lease is of exceeding 1 year, it should be done by the registered document. So for this, A will be the right answer for this question. Is that okay? Now, next. The transferor is called what? Maker, mortgage, mortgagee, mortgager. Tell me, class. A person, B person. B have given money to the A person, right? And this A person, okay, he is giving immovable property as a security to the B person. So this is called transferee and this is called transferor. Now you have to tell me this transferor is called what? Is that maker, mortgagee, mortgage or mortgager? So Deepak sir, Meera ma'am, Anirudh sir, excellent. That is called mortgager. Good. Next, dash is a special kind of bailment. It is pledge, lien, check or promissory note. Tell me, guys. Dash is a special kind of what? Bailment. Special kind of bailment. It's a pledge, lien, check or promissory note. Meera ma'am, why you say lien? Ma'am, lien means to hold something, na? Check, and promissory note, that is a kind of negotiable instrument. But ma'am, pledge is a kind of bailment, na? Pledge. The answer would be pledge. Why, ma'am? Because in the bailment, there is a transfer of property. In the pledge also, there is a transfer of property. So the right answer will be pledge. Excellent, Deepak sir. That's great, Meera ma'am. Okay, guys. Now, next. Integrated ombudsman scheme applies to Central India, South India, whole of India, North India. Tell me. Excellent. So guys, the excellent Deepak sir and ma'am, whole of India is the right answer. Okay, that's cool. Okay, ma'am. Agreement of lunatic, lunatic means a mad person, idiot and a drunken person are dash similar to the case of minor. It is void, valid, voidable and available for a specific period. What is the right answer? Agreement of lunatic, idiot and the drunken person are dash similar to the case of minor. What is the right answer? What is the right answer of this question? Excellent. If any agreement is done by these persons, the agreement is void agreement. And void agreement, we know that from the initial stage, it is totally void. Okay, cool. The right of set off is also known as right of dash, combination of account, comparative statement, appropriation of payment, or bookkeeping. What is the right answer? Right to set off. That term, that is the right of bank. So this is also known as right to combination of account, comparative statement, appropriation of payment, or bookkeeping. Excellent. Excellent, Jagruti ma'am. Most welcome. The right answer is appropriation of payment. That is the right answer. Okay, that's cool, sir and ma'am. Okay. For DRT, that is a Debt Recovery Tribunal, the presiding officer who is the head of DRT hold office for a term 5 years from the date on which he entered into office or until the age of 65, whichever is less. That is correct, incorrect or C and D. Tell me the right answer. What is the right answer? Is that correct? Because in chairman, that is the chairperson, that is the head of the DRAT, tenure is 5 and 70. You have to learn 5 and 70. And for this question, excellent, ma'am. The statement is absolutely correct. Good, ma'am. Next, a civil suit which is pending stand transfer to the DRT. Then the fees payable will be, the civil suit is pending, okay, in the court. Now this case is transferred to the DRT, then the fees payable will be in the DRT, will be decided by DRT. Standard fees should be paid, no fees required to be paid, and none of the above. What is the right answer? What will be the right answer for this question? Excellent. So the right answer for this question, excellent. No, 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 ma'am, not standard fees. No fees is required to be paid. Ma'am, that is the reason now that whenever we file the case in the court, we have to pay some amount as a fees. But in ma'am ADR system now, we do not require to pay any fee. So that's why we basically refer our matter in the ADR systems. Okay, so C is the right answer. Okay. Appeal before appellant tribunal, it means from DRT to DRAT, okay, to dispose of finally from the date of receipt of appeal within 3 months, 4 months, 180 days, or 1 year. What will be the right answer? What will be the class right? It means in how many days the DRAT have to finish the matter. Tell me, in how many days? Excellent, ma'am. The right answer for this question is absolutely 180 days. So this is the right answer. Good. Okay, 180 is the right answer. Okay. The correction any clerical or arithmetical mistake in the recovery certificate. C class. The recovery certificate is issued by the presiding officer. So if there is any correction in the clerical and the arithmetical matter, that is done by the, okay, that is done by whom? Concerned clerk himself, presiding officer of the tribunal, recovery officer, or any of the above. Tell me, what is the right answer? What will be the right answer for this question? Tell me, guys. That's great. Many students tick mark on the recovery officer, but recovery officer is the not right answer. The correct answer is class. The presiding officer will be the right answer. Great, class. Now, which of the following case the constitutional validity of SURFACE was questioned before Supreme Court? Manchester Chemical versus ICICI Bank, Manchester's Chemical versus Union of India, Madhya Chemical versus Union of India, okay, and Madhya Chemical versus ICICI Bank. Which of the following is the right answer? And we know that whenever a new act is made now, it have to be, you know, it have to be verified by the constitution, and constitution is the father of law. So you have to tell me in which case it was decided that the SURFACE Act is a valid, but one section of SURFACE Act is not valid, and that was, if we want to appeal, we have to pay the 75%. That is not correct. Excellent, sir and ma'am. Excellent. The right answer is Maria Chemical versus Union of India. C is the right answer. That's great. Under the provision of SURFACE Act, a charge on movable property in the favor of secured without delivery of possession to the creditor is called what? Mortgage, assignment, pledge, lien, and hypothecation. What is the right answer? Just analyze yourself. Okay, class? Analyze yourself. That how much question you people know. Tell me, class. Without delivery of possession. Without delivery of possession, sir. Movable property, Anirudh sir. Movable property. Arey Baba, Deepak sir. It's a movable property. We are not giving delivery, but that property is secured one. What is this? You people know the answer. You people know the answer. That is not mortgage because mortgage deal with the immovable property. Assignment to assign someone. Pledge movable. Lien to stop to hold something. But hypothecation is the right answer. It's a E ma'am. In hypothecation, suppose if Nikita ma'am want to purchase a car, right? So I will not transfer my car to the bank. I will just submit the document to the bank. This is hypothecation. My car is movable property. So E will be the right answer. That is a hypothecation that is given in SURFACE Act. Section 2N talks about the SURFACE Act. Okay, cool. Next. If sale of secured asset, the dues of secured creditor are not paid fully. So what option the secured creditor have? Secured creditor means to whom we have given the security. That is called secured creditor. So what option he have? He has a right of the same. He can file suit in a civil court. He can file suit in a DRT, in DRAT, or both B and C. What will be the right answer for this question? Yes, yes, tell me, tell me. Okay, he can file suit in a civil court. And DRT is not there, sir. Huh? DRT is not there. I think DRT is also there. Court is but obvious, but DRT is also there, na? So the right answer for this question is E is the right answer. That is B and C. So B, he can file suit in a civil court, and C, he can file suit in a DRT. So E will be the right answer. E is the right answer. We can file case to the civil court also, to the DRT also. We have an option, no? We basically go to the DRT, but we have an option also to file the case in the civil court also. So that's why E will be the right answer. Okay, next. When the seller manipulate the price, it is known as caveat emptor, unfair trade practices, restricted trade practices, or none of the above. What will be the right answer? Tell me, class. What will be the right answer, class? Tell me. When the seller manipulate the price, manipulate. When the seller manipulate the price, it is known as, okay, it's a caveat emptor, unfair trade practice, restricted trade practices, or none of the above. The right answer will be, that is restricted trade practices, that is given in the definition term. But you people have not seen the definition term. That's why Anirudh sir, Deepak sir, you have given the wrong answer. In the YT session, I have completed the definition terms of the All Act summary session, module wise question. It's a request to all of you to please see the session. That is very important from the examination point of view. Is that okay? Now, let's do the some case studies question. Okay, the case studies question will be very good. See, in the case of Balfour versus Balfour, that is a case name, a husband promised to pay his wife a household allowance 30 rupees, that is pound per month. Later the party separated and the husband failed to pay the amount. Now the wife sued him for the allowance. Decide the validity of such agreement in the light of provision of Indian Contract Act. So it means that this question is from module D, that is Indian Contract Act. So you have to tell me what will be the right answer. Yes, it is valid agreement as it satisfy all the essentials point of contract. No, it is not a valid agreement because there is no intention to create the legal relationship between husband and wife. C, yes, it is valid agreement as it was duty of husband to pay maintenance to his wife and her well-being. D, no, it is not a valid agreement because there was a no agreed promise reduced in writing. Just apply your common sense and tell me the answer. This type of question is called class case studies question, and 10 to 15 question will come that types. 10 to 15 question. Tell me, a very good question. We have read, I think, the essential points of a contract, right now. So we have read the essential points of contract. So in a one essential point, the answer is there. Apply your common sense. Suppose if a husband wife get divorced and the court have ordered that the husband have to pay 30,000 rupees per month. So this is the order. This is the order class, and husband have to pay. If husband will not pay, the wife can file the suit. But in this case, Jagruti ma'am, you can see that the husband promised to pay household allowance. It means a household thing, and he just promised that I will give you 30 pound per month. It is just a promise, ma'am. So suppose if husband not fulfill the promise, we can file the case. Tell me, Meera ma'am, your husband say, Meera ma'am, I will give you a necklace at the evening. But at the evening, nothing is there. So you will file the case. In this contract class, tell me, in a contract, we have to create the legal relationship. In this contract, the legal relationship is created. Tell me. The answer is no. The validity of the agreement, no agreement exists, no agreement exists. So answer should be from B and D. What is B? It is not a valid agreement because there was no intention to create legal relationship. No, it is not valid agreement because there was no agreed promise reduced in writing. Exactly. So the right answer will be there is a no creation of legal relationship between husband and wife. So B will be the right answer for this question. Are you getting my point? Meera ma'am, Deepak sir, the question is clear why the B is the right answer. Because in the husband wife, we cannot create the legal relationship. It is just a social promise or domestic promise that generally happen between the husband and wife. So that's why for this one, B will be the right answer. Now got it? Andrew sir, this question is clear or not? Tell me. This question is clear or not? Tell me. Tell me guys, this question is clear? Okay now? Chaliye, next question we will do. SL Fernandez versus VM Fernandez. The plaintiff was the owner of liquor sale. Plaintiff is the owner of liquor sale and bar with license. It means the plaintiff have a license also. He made a contract with defendant. First of all, what is plaintiff? What is defendant? Plaintiff means the person who filed the case. Defendant is a person to whom we file the case. To whom we file the case. So the plaintiff made a contract with defendant in which he entrusted his business. Entrusted means the plaintiff give his business to the defendant and receive a yearly payment, eventually transfer the full control letter. It means the plaintiff hand over the defendant the full business to the defendant. Okay, now, but defendant did not hold any license. This is a crux point which will give you the hint of the answer. The defendant did not hold any license to sell the liquor. The plaintiff brought an action against defendant for not paying the yearly payment. Now, which of the following is appropriate decision that will taken by the court? A very good question. Tell me, class. The plaintiff cannot recover the amount as the business was without license was prohibited by law. The plaintiff cannot recover amount as there was no written agreement between them for the yearly payment. The plaintiff can recover the amount as he was authorized owner. And D, the plaintiff can recover the amount as he transferred his business lawfully, initially received payment too. Tell me, class. What will be the right answer for this question? The plaintiff cannot recover the amount as the business was without license, prohibited by law. The plaintiff cannot recover the amount. There was no written agreement between them. In the fact class, it is not written whether the agreement is written or not written. Okay. So first of all, C class, if a defendant does not have a license, it means the plaintiff cannot recover the amount. So the answer can be from A and B. The plaintiff can recover? No. Because this is not a written agreement. So in this question, the plaintiff cannot recover because the business was without license, was prohibited by law. So guys, A will be the right answer for this question. A. Is that clear or not? Why you people are not giving me the answer of this case studies question? Is that hard? Exactly. Exactly, Anil sir. This is a common sense question. Common sense question. Is that hard? Question is hard. Huh? This type of question will come. So you have to apply your common sense. It is basically without license. Exactly. And should be D. Why D, ma'am? No, ma'am. See, ma'am, the plaintiff, you are saying that the plaintiff can recover amount because he transferred the business lawfully, ma'am. I know that the plaintiff have transferred the business lawfully, ma'am, but he have given that person who have a no license, ma'am. So, ma'am, ignorance of law is no excuse. Jagruti, ma'am. Ignorance of law is no excuse. If I violate the traffic rules, Anirudh sir, Now tell me, suppose since from 20 year I'm living in USA. When I come to India, right, and I have just break the traffic rule. Can I say this thing that, sir, I don't know the rules of traffic rules, so that's why I will not, you cannot give me the punishment. Can I say this thing? Andrew, sir, tell me. Can I say this thing? Sir, I don't know the law of India. Sorry. Can I say this thing? The answer is no. Ignorance of law is no excuse. Is that okay? Ignorance of law is no excuse. So plaintiff when knew that the defendant have not license and he have still given the business, so there is a default of plaintiff. Okay? Is that clear? That's great. See, ma'am and sir, from Monday onwards now, from Monday onwards, for 1 week, I'm going to start at 8 p.m. the case studies question like this. So you have to attend the class from Monday onwards. Okay. Monday is 20 of November. So from Monday onwards, I'm going to start the session. Okay. Now cool. Next. A leading case, no need to learn the case name. This is the case name in which the partnership firm consisted two partners who represented their joint families. Okay. In the partnership deed, there was a provision for an heir or nominee taking the place of deceased partner. Okay. One partner out of the two dead, leaving his widow and the minor son. The issue was whether which consisted of two partners were dissolved after the death of one of the partner. Okay, it means class, in the partnership deed, it was written, see, when one partner will dead, the partnership will be dissolved. Now you have to tell me, decide the validity of this partnership firm as whether it still exists or it get dissolved. Tell me. This is simple question. This is simple question. A, the partnership will exist as it is a set of principle of law that where one of the partner die, the firm is to be managed by other partner. The partnership still exists, the partnership stand dissolved, and the partnership shall dissolve. What is the right answer? That is easy question. Tell me class, what will be the right answer? Deepak sir, Anirudh sir, what is the rule of partnership firm? Could you tell me? What is the rule of partnership? Tell me. What is the rule of partnership class? Suppose there is a two partner or three partner. Guys, if these partners dead, the partnership will still exist. Tell me. If two partners are dead, the partnership will still exist or not? Tell me. Tell me, tell me. In this deed, it is written only that the heir and nominee taking the place of deceased partner. And one of the partner died and that partner have a widow and a minor son. So what our section 4 of the Partnership Act say that? Tell me what the section 4 say. Yesterday I have just show you this particular section based session. So class, in this case, first of all, the partnership will be dissolved because one partner cannot do the business. And this is not a company. In the company, the perpetual succession will exist. But in this question, the perpetual succession will not exist. Just apply the formula of partnership firm. the partnership is dissolved because if one of the two partners of the firm die, the firm automatically comes into end. Thereafter, there is no partnership of third party to be introduced. C will be the right answer. We have done the session of dissolution of partnership firm. So in the dissolution of partnership firm, compulsory dissolution, in the compulsory dissolution, Deepak sir, this point was there. Is that clear, sir and ma'am? That's why from Monday onwards, Deepak sir, I'm going to start this session. That is very important. That is very much important. Okay, that's cool. One more question. X took a big television from this company on rent. The rent agreement provided that the company shall not be liable for any personal injury to the hirer or to any other person while using it. However, due to the defect in the television, Y wife X was injured. Okay, Y brought an action against this. Which of the following is the correct answer? Y cannot succeed because X can claim damages from this. Y cannot succeed. Y would succeed. Y cannot succeed. First of all, tell me the Y would succeed or not. The television is on rent. The rent agreement say the company is not liable for personal injury if any while using the TV. This clause is right or wrong? Tell me. This clause is right or wrong? Tell me. This is very simple question, and this type of question from tomorrow onwards we will do this one. So the right answer will be, ma'am, this exemption clause is the right one. Meera ma'am, if the shopkeeper is saying that, I will not be liable if any defect will happen from my this one, this is not a valid one, ma'am. Why would succeed? Why would take compensation? Exactly. Okay, don't worry. So this types of question I will tell you from tomorrow onwards. Okay, from day after tomorrow, from the Monday at 8 p.m. we will do these types of question. Okay guys, so that's all for today's class. This is called case studies question, and ma'am and sir, 10 to 15 questions will come from this one. 10 to 15. Okay, so this is your new batch from of June session, new batch. Okay, Sankalp comprehensive batch. So do not worry, just try to revise all the questions so that it can be very easy for you people. Done? This is your what? Sankalp comprehensive series. This is Mahapack. If you want to enroll, you have to apply the coupon code, that is 5391 for the maximum discount. So that's all for today's class. Have a nice day. Okay. So if you want to purchase it, because right now we have just also introduced the revision series. Okay, so if you want to purchase the revision series now, you can purchase. My BRBL subject revision series will be start from the 1 of December. Okay, so this is your CAIIB November. This is November. Okay, so this is your batch. Okay, so use the coupon code Y391 for the maximum discount up to 81%. That's all for today's class. Have a nice day.